Our next speaker is going to speak about profile stops, and he's going to speak about some other things. And he's got a pretty impressive speaker bio, if I do say so myself, but I really decided to do a little research and read between the lines. And he claims to have gone to college in Colorado and law school someplace in Berkeley, or Old Hall. He was reduced to the public defender's office in Brooklyn. It was the only place you could get a job after school, apparently. Did that. Somehow he did wind up back in Colorado. Times must have been tough, though. He had to take a second job teaching. And I think the bottom completely fell out in 1995 when he was given the Jonathan Olam Award by the Colorado Criminal Defense Bar. It's given to the Colorado criminal defense lawyer who works in defense of the accused without regard to personal gain. It's a nice way of saying he didn't get paid. Truly hit rock bottom recently. He can't even get Colorado clients anymore. Had to go to Cuba, and he represents 5 people in Guantanamo. I've got the Aspen market wrapped up tight. I could throw you a client or two. No, in all seriousness, read the bio of this man. He is a very high caliber lawyer, and that's even quite an understatement. But we haven't told him yet he's not being paid for this. But I present David Lane.
As many of you know who are practicing law, being busy and getting paid are completely separate things. And most of us have spent most of our careers being very, very busy and not really ever getting paid. But that's the way it goes. I'm going to give you a little background on me beyond what Mark said. Because the way I come at this topic is via the criminal defense route. But I'm also a civil rights lawyer, and my practice over the years has become more and more civil rights. My criminal cases these days are essentially death penalty defense and municipal ordinance violations, because muni ordinance violations lead to civil rights lawsuits. And so my civil rights antenna went up when we were all told, watch your language, because this is being broadcast on NORML radio, or 420 radio, which immediately made me want to tell you a story about a guy who owns a bar down in Colorado Springs, and he scrawled the word fuck all over his bar. And the Liquor Commission came in and said, we're going to shut this place down because of all these obscenities. And there was a lot of First Amendment litigation surrounding that incident. And of course, the bar owner prevailed, and his comment to the press that they couldn't print afterwards was, you say potato, I say fuck you. Yeah. So, anyway. I have to kill a lot of time here because the law on the topic I was given is so outrageously bad that I just don't have a lot to say to you. All right? But let me give you some background on how this all goes. The Supreme Court, over the last maybe dozen years, has had a very, very unfortunate habit of saying that as long as the Fourth Amendment has not been violated, virtually anything goes. After that Fourth Amendment hurdle has been leaped by the police. What I'm talking about is that back in the good old days, when profiling actually was something that you could litigate in court, the standard was this. The standard used to be that the question was not, was there probable cause to believe somebody was speeding 1 mile an hour over the speed limit? The test was, would a reasonable officer, given all the totality of the circumstances confronting this officer, have made the stop but for some unconstitutional or illegal motivation. What that translated into was, yes, as a technical matter, your client was going 1 mile an hour over the speed limit, but would an FBI agent have made a stop? Because even though they have the technical ability to do so, would a reasonable FBI or DEA agent have made a stop on somebody going 1 mile an hour over the speed limit? And the answer to that was obviously no. Then you could make an inquiry into the subjective motives of that particular law enforcement officer, and then you could determine what was the actual motive for the stop. And the actual motive for the stop could be an unconstitutional motive, such as race-based drug courier profiling, or some other constitutional infirmity. That was the standard, and that was extensively litigated. And in fact, I had a case where that very thing was happening. It was, there are 2 reported cases as a result of this. One is called United States versus Louis Laymon, Laymon, and that was a federal district court opinion out of the District of Colorado. I represented Louis Laymon. It was a CJA appointment, and Mr. Laymon and his soon-to-be co-defendant were traveling eastbound on I-70, coming across the mountains in Eagle County, Colorado, which is Vail. They had California plates on their car, and it was a rental car. The Eagle County Sheriff's Department pulled them over allegedly because they were weaving. Somehow they ended up allegedly getting a consent to search. And they searched the rental car by removing various panels and compartments. They found approximately 3 kilos of crack cocaine in a secret compartment in the trunk. At that time, 3 kilos of crack was the biggest crack bust in the history of Colorado. And the DEA and the Eagle County Sheriff's Department posed with drugs on the table, 3 kilos of crack, and you know, there was a lot of press given to ACE law enforcement and how great a job they were doing with drug interdiction on I-70. Because as we all know, I-70 is a pipeline. It's a pipeline called an interstate highway, and unlike all the other pipelines here and there, this pipeline, they're cracking down on this particular pipeline. Well, Judge Jim Kerrigan was on the bench at that time, and he was a wonderful, wonderful federal judge. He ended up getting off the bench when the federal sentencing guidelines became mandatory because he said, I am not going to be following some grid pattern to determine what is and is not justice. So he resigned from the bench, unfortunately, because that kind of mentality helps all of us if it stays on the bench. But he wasn't going to be a slave to the federal sentencing grid guidelines, which were mandatory at the time, and so he resigned. But in any event, my client had informed me that there was absolutely no way they were weaving. They were super paranoid, knowing that they had 3 kilos of crack, which, by the way, even as we sit here today in this room, possession, simple possession of 3 kilos of crack cocaine is a death-eligible offense under federal statute. There is no federal prosecutor anywhere that's ever tried to get a death penalty for that, but it is on the books right now in your United States Code, Title 18. Possession, simple possession of 3 kilos of crack is a death-eligible offense. But in any event, my client informed me, no, they were not weaving. The cops threatened them with bodily harm if they didn't sign the consent. They signed the consent, hoping that the secret compartment was not going to be discovered. The secret compartment was discovered, and on we go. I started to look at the case and started wondering, why is the county sheriff stopping people for traffic on I-70? That's the job of the highway patrol. That is not the job of the county sheriff. I then learned about this thing called Operation Pipeline. Operation Pipeline back in the day was a joint effort by the DEA and local law enforcement to, quote, go beyond the stop, get consents to search, and everything has to be very well documented, and everything has to be recorded, appropriately so that they can get DEA money to fund their operation. So they have to have a list of everybody they stop, when they stopped them, what their license plate was, et cetera, et cetera, et cetera. Judge Kerrigan authorized me to issue a subpoena duces tecum to the Eagle County Sheriff's Department, where I wanted a list of everybody over the last 6 months that had been stopped by the Eagle County Sheriff's Department on I-70 for a traffic violation. They fought it. Judge Kerrigan ruled in my favor. I ended up getting all of their meticulously kept records so that they could get DEA money. And what I discovered is that 98% of everybody being stopped had an out-of-state plate, mostly California plates, and approximately 50% of everyone who was stopped had a Spanish surname, according to the United States Census Bureau's list of Spanish surnames. We then had everybody's plates and their names. We then got records from wherever their state of registry was. We ended up contacting people who were stopped. And my investigator would call people and say, hey, Mr. Gonzalez, my name is so-and-so. I'm an investigator in Colorado, and we have records that show that you were stopped last March traveling eastbound on I-70 from Los Angeles. Do you remember that? And Mr. Gonzalez would say, oh man, yeah, I remember that. Those cops stopped me, took me out of the car, made me sign a consent to search form. They kept me on the side of the road for 45 minutes. They took panels off my car. They overturned my luggage on the street. Cars are whizzing by. It was cold. I had kids in the car, and they didn't find anything, so they said, all right, you're free to leave. I said, well, who's going to put my car back together, and who's going to put all this stuff away? And their answer was, that's your problem. I said, well, they said you were weaving. He said, I wasn't weaving. I said, did you get a ticket for weaving? He said, no, I got a written warning for weaving, but I wasn't weaving. Well, this was a pattern that we discovered in case after case after case. And we brought in witness after witness after witness to federal district court to testify that what was in reality going on was not traffic enforcement, it was drug courier profiling. Judge Kerrigan suppressed 3 kilos of crack cocaine, and the case got tossed. There were huge lessons to be learned. Well, I appreciate that, thank you. There are huge lessons to be learned, and I could give a whole other lecture on how to deal with the media when you have a case. Because ultimately, what became biggest crack bust in Colorado history, the headlines in the Denver Post turned into Eagle County, Mississippi in the mountains, question mark. And that was all directed and intended, and it changed because I never say no comment to the media. When you say no comment to the media, you're simply saying my client is guilty as hell, and so please just leave me alone. But that's a whole different lecture. But in any event, we then filed a class action lawsuit on behalf of all of the hundreds of innocent travelers that had traveled across Eagle County over the years and had been stopped by the drug task force. We ended up settling that class action for close to $1 million paid out by Eagle County. And then the United States Supreme Court changed the rules of the game. And a case came down, and it's in your materials. It's called United States. It's Wren versus United States, WHREN. And the Wren case has now been extrapolated into other case law where the Fourth Amendment is the super amendment in the Constitution. The only relevant inquiry after Wren is, was the Fourth Amendment violated? If the answer to that is no, anything goes. Meaning, we don't care what the totality of the circumstances are. We don't care if there is no DEA agent on the planet who would reasonably stop someone for going 1 mile an hour over the speed limit. The only inquiry is, was this guy going 1 mile an hour over the speed limit? If the answer to that is yes, the director of the FBI could pull him over, and there's no Fourth Amendment violation. And if this guy consents to a search of his car, and they find drugs, and the only reason they pulled him over was to get consent to search and find drugs, we don't care. This is a really, really negative development in the law, and now they're trying to stretch it into other areas. I had a case that I argued in the United States Supreme Court last year. It's called Reichel versus Howards, where Wren became the focal point of the argument. And the issue was my client had gone up to Dick Cheney on the mall in Beaver Creek, Colorado. Everybody on the mall is slapping his back, shaking his hand, telling him what a fabulous job he was doing as vice president. My client walks up to him and says, "I just want you to know I think your policies in Iraq are disgusting. Have a nice day." Touches him on the shoulder and walks away. 20 minutes later, the Secret Service runs up on him, flashes their badges, and tell him, "We want to talk to you about assaulting the vice president." He said to the Secret Service, "I didn't assault the vice president. I criticized him publicly, and if he doesn't want public criticism, he should remain at his undisclosed location." They ended up arresting him for harassing the vice president. They couldn't convince a U.S. attorney to indict based on the fact that they let him walk away 20 minutes after he allegedly assaulted the vice president, and the U.S. attorney said, "How are we going to ever explain to a jury why 30 Secret Service agents let this guy walk away after assaulting the vice president?" And then the Eagle County DA, to his credit, said, "How am I going to explain why 30 Secret Service agents and 50 deputy sheriffs let the guy walk away after harassing the vice president?" All criminal charges got dismissed, and we then filed a civil rights lawsuit saying he was arrested in retaliation for his First Amendment free speech. We get a green light from the district court in U.S. District Court to go to trial. They take an interlocutory appeal up to the 10th Circuit. The 10th Circuit says, well, even though there was probable cause to believe that he had committed an offense, the offense being when they questioned him, they said, "Did you assault the vice president?" And he said, "No." They then said, "Well, did you touch the vice president?" And he had actually forgotten that he had touched him on the shoulder and said, "Have a nice day," as he was walking away, which is not a crime. The 10th Circuit said he did lie to federal investigators, which is a 1001 violation. So they had a technical violation they could have arrested him for. So the issue became framed from the perspective of, well, if they could have arrested him and not violated the Fourth Amendment, because they had probable cause to arrest him for lying to them about having touched the vice president, but their actual motive was to punish him for his free speech, can the case go to trial? And the government was citing Wren as standing for the proposition that as long as probable cause exists, it doesn't matter what their actual motives were. There is a split in the circuits. The 10th Circuit came down on our side and said, no, under these circumstances, if you have a First Amendment violation, even though the Fourth Amendment may not have been violated, if the First Amendment was violated, you have a cause of action. The Ninth Circuit has said otherwise. The Sixth Circuit has said otherwise. Various circuits have come down in different ways. So cert was granted by the U.S. Supreme Court. Kagan had recused herself because she was in the solicitor's office at that point when the case was working its way up. So what ultimately happened is I argued the case in the U.S. Supreme Court. I got a massively hostile response from the predictable justices. And what they ended up doing is they said the law in this area is not well settled. And we are not going to well settle it in this opinion. We're not going to do it. And the only conclusion I can come to is it was going to be a 4-4 split. And they didn't want to decide the issue on a 4-4 split, and simply, which results in an affirmation of the 10th Circuit opinion. So they simply said, the law is not settled and we're not settling it. So the good news is, the bad news is I lost 8-0. The good news is no harm was done to the First Amendment. They're saving that for another day. But the issue now for us, in terms of profiling Colorado plates coming out of Colorado, when you hit the Kansas border and you get stopped, what is left in your arsenal? What can you do about this kind of misconduct by the police? Because if you take this Wren decision to its logical conclusion, you could have a Klansman who happens to be a cop, and he says, I'm just going to stop African American motorists. That's it. And as long as they are violating the law, he can get away with it. It doesn't matter that all he's doing is stopping African Americans. Because if you're speeding, you're speeding. You may have a separate cause of action under various civil rights statutes that you could bring against this cop, for race-based, stopping. But it has nothing to do with suppressing evidence. It has nothing to do. A Klansman who's a cop could get on the witness stand and say, yes, Your Honor, I stopped him because he was black and had Colorado plates. That's why I targeted him and let all these other speeders go. All right, but he was speeding. He was going 1 mile an hour over the speed limit. Here's my radar gun proving it. So I stopped him, and the judge could, do what judges these days do, which are, generally wring their hands and cluck their tongues and wag their fingers, but not much more when it comes to controlling law enforcement. And I say that as a lawyer representing 5 Guantanamo Bay detainees. The best we'll ever get out of the court is hand-wringing, tongue-clucking, and finger-waving. Not much else in the terms of any substantive relief. So, how do we fight profiling of Colorado plates? And the answer is, that's an excellent question. I don't have a good answer for you. That's the topic I'm given to talk about. So here's what I want to do. I want to throw this out to all of you because you're all a bunch of smart people who are very engaged in this issue. And let's figure it out. I mean, the way that the case law has come down is, first of all, to stop someone and briefly detain them, you don't even need probable cause. All you need is reasonable suspicion under the law, which is lower even than probable cause. The former chief judge of the New York Court of Appeals was once heard to say a prosecutor could get an indictment on a ham sandwich. Well, to get an indictment on a ham sandwich, you need probable cause. That's how low the standard for probable cause is. You could get an indictment on a ham sandwich. Reasonable suspicion is even less than that. If you reasonably suspect that someone is going 1 mile an hour over the speed limit, that's enough to stop someone for a brief detention. What then do you need to do for further investigation? A cop could say, well, I smelled the odor of marijuana. Once I stopped this person and they rolled down their window, I smelled marijuana, and I said to them, I want to search your car. If a cop says, I could clearly smell marijuana in the car, that would give probable cause to the cop to believe marijuana was possessed in the car and could result in a search. The law on drug dogs, bringing drug dogs in for a little walk around the car is terrible. They can briefly detain you while awaiting the arrival of a drug dog. And a brief detention has been described as probably lasting no more than 20 minutes for the arrival of a drug dog. If they keep you there for more than maybe 20 minutes while the drug dog is en route, that may be an unreasonable detention. But again, reasonableness is in the eye of the beholder, and unfortunately the beholders here are all wearing black robes. And very little is unreasonable in terms of law enforcement conduct. The way I think we can combat this is to take a page out of the race-based drug courier profiling handbook from years ago, where various journalists would set law enforcement up with sting operations. They would have an African-American reporter or an African-American driving while black through a race-based drug courier profiling corridor without estate plates, and the whole thing would be on tape. They would have it right there in the car. They would have hidden cameras going, they would have recorders going, and they would record the stops, and just to see how it was all actually going down. The way that it could be done now, I think, would be smoother and better, but it would be a resource-intensive kind of a thing, and who really is going to be engaged in this? I mean, people driving frequently from Colorado who are tired of getting stopped with their Colorado plates might have an interest in doing this, but I mean, if you get stopped with marijuana in your car and they find it in Kansas, you're just done there. And being, that you can't make an allegation that you're a member of a protected class, i.e. someone with Colorado plates. That doesn't cut it under the law. Being, from Colorado is not the same as being African American or, they did it because of your religious beliefs, et cetera.
So in Oregon, they're targeting California plates and Washington plates, but they're targeting patients, really. And I'm wondering if there's a way to expand protected class to include cannabis patients.
If anything, the Supreme Court is more inclined to cut back on protected classes. It's where it's going to be interesting. I mean, I'll be very interested to see how the DOMA litigation comes out, because I think that will possibly touch on some relevant aspects of this, and that is the full faith and credit clause going from state to state. If your marriage is legal in one state, really, every other state has to recognize it as legal. That's why when you drive, you have a Colorado driver's license, but it has to be recognized by every other state. You can't be forced to get a driver's license every time you cross a state line. Every other state has to give full faith and credit to your driver's license. There was some proposals in Congress among various right-wing groups recently to give full faith and credit to concealed carry permits. If you have a concealed carry permit in one state, the most restrictive state in the country has to give full faith and credit to it. So you can carry your gun through New York City, without fear of arrest if you have a Texas concealed weapons permit. That died in Congress. But a lot of people were interested in seeing that pass. Jerry?
One thought is many states have their own state constitution, and for example, Colorado has a specific state constitutional right to privacy under Article 2, Section 7, that might be open for litigation in the adjacent states under their state constitutional provisions, if we have a state Supreme Court that has the backbone to actually uphold it.
Well, that's true, but in terms of a cop saying, I had reasonable suspicion to believe that this person with the Colorado plates was speeding, but I didn't even, they don't even have to give you a ticket. I mean, the cop could then say, when they find pot in the car, they could say, oh yeah, I had reasonable suspicion, but I didn't use my radar gun. I didn't clock him. I just reasonably suspected that he looked like he was going a little fast, so I pulled him over, and then I smelled marijuana. So what it's going to take, though, is you're going to see patterns develop. It's going to be the same cops over and over and over again in the same jurisdictions over and over and over again, doing the same thing over and over and over again. And what it's going to take is some digging like we did in the Lemon case, where we contact people who are getting stopped and getting searched. by these cops, and they're not finding any marijuana, but it's going to be people from Colorado who are getting stopped on the border of Nebraska or Utah or Kansas by the same cops, and somebody who ultimately wants to do something about it is going to have to file a civil rights lawsuit saying, I got stopped without so much as reasonable suspicion. This cop stopped me only because of my Colorado plate, which is not reasonable suspicion. So my Fourth Amendment rights were in fact violated. Even under this ultra low standard, my rights were violated, and the way I'm going to prove this is ultimately to subpoena this cop's records of stops and police agency records saying, you know, Officer Smith at mile marker such and such again stopped for the umpteenth time a Colorado plate and claimed he smelled marijuana, searched the car but found nothing. And then we can show a judge maybe that this cop is just a liar. When this cop says, I mean, when I was public defender in New York, and it's interesting, Lauren has experience in New York in the criminal justice system, there was a series of cases where the cops in Brooklyn, primarily, would walk up to my clients who were almost invariably young African-American men, and their reports would read like they, you know, every report was identical. He then started to walk away from me, and I saw something fall out. He immediately threw something on the ground at his feet in a glassine envelope. It turned out to be crack cocaine. And I would talk to my clients, and I'd tell them, you know, the cop says you threw it. And they'd say, are you out of your mind? I mean, do you think I would, first of all, throw crack cocaine away? Second of all, do you think I'd do it while a cop is watching? You know, and it got so bad that the highest court in New York, the New York Court of Appeals, called these dropsy cases. And they said dropsy testimony as a matter of law is bullshit. And, you know, so that ended dropsy. And it's going to have to go the same way here. Laura?
Question, can you discuss, you talked about recording or having the drivers record the transactions that are happening. Can you discuss, as attorneys, our ethical limitations on having people record, being involved in the recordings, or how do we make this happen without violating other ethical obligations?
Well, there is a prohibition against attorneys taping surreptitiously in most states. But that has been litigated, and that has been thrown by the boards, essentially. How is it that prosecutors can send in an informant with a wire anytime they want? I mean, the informant is acting as an agent for the prosecutor, and they're taping everything your client says. And so you do have a right to tape in most states. There has been litigation. Cops have pushed it to the point of breaking, where people with cell phones standing there watching cops abuse somebody, cops have charged the person with the videotape with wiretapping, because they're tape recording a conversation without the consent of either party to the conversation. It's happening on the street. You know, you're just a passerby and you tape this whole encounter, and you don't have that guy's consent or the cop's consent, and so they say that's an unlawful wiretap, and we're prosecuting you for unlawfully wiretapping. And the courts have put a stop to that. Case law on that is good. But now, you know, with GoPro and, you know, a little GoPro camera in the car, you can wire up a car, you can get, you know, high resolution pictures and good audio tape. And a lot of these cops are going to try to get consent, and mere acquiescing to authority is not actual consent. And what happens is, you know, cop will stop you and say, you know, I think I smell marijuana. Can I have consent to search your car? Or the cop will say, you know, you guys aren't carrying anything, are you? No. Well, you don't mind if I search your car then, do you? And if it's on tape where you're saying, no, I do mind if you search my car, and no, you cannot search my car, they will threaten you. They'll say, well, you know, I think you got drugs. You can sit here for an hour or 2 hours till I bring a drug dog out, and we can have the drug dog tell me if the drug dog smells drugs, and you're going to sit here for an hour or two. Or we can just tow your car to the impound lot right now and search it. Or you can just let me search. What do you choose to do? Well, if you don't have anything, you might say, okay, search the damn car. But what I'm saying is setting these same bad cops up with GoPro cameras and audio recording and making them out to be the liars that they are is really about the only way I can think of to bust through profiling in the Ren era. Mm-hmm.
Is it possible if we establish an upward pattern of targeting Colorado residents that you could file a claim that your right to travel had been violated?
Well, that's a really interesting question that has not been litigated. Under the Commerce Clause, they cannot put up barriers to interstate travel, and in fact, under civil rights actions, Ollie's Barbecue, what gave the feds the ability to enforce civil rights law was these segregated restaurants throughout the South. And they said the federal interest in not allowing public accommodations to be segregated is that it impedes interstate commerce. Because if you're African American, your ability to travel on the interstate highway system is compromised because there are so many restaurants that won't serve you because you're black that you're not going to travel. And so that gave the feds jurisdiction. And that, that's why I'm so glad I'm here, because I had never thought of that. That is possibly brilliant. I will go so far as to say that is possibly brilliant. Okay, I'll say it's brilliant. I don't know if it would work or if it would fly. But yeah, I mean, stuff like creativity like that is what we need.
I litigated right to travel and full faith and credit and equal protection in Oregon on a California patient and their recommendation. And they said the Court of Appeals said on full faith and credit that we're not interfering with your limited immunity in California. You still have your limited immunity in California. And they treated the right to travel argument, and I agree with you, the best part of it is you get to cite cases like the Hard Atlanta Motel. You get to research about different medical care that can't be denied people who are coming through your state. And they treated it as an equal protection thing, read the statute about who can qualify for the protection of the Oregon law as...
The story doesn't have a happy ending, I can tell you.
Well, it does have a happy ending.
Okay, good.
I lost the case and changed the law.
Okay.
They said that well, let's look at the statute, and it's either ambiguous or it's not ambiguous. We find it's ambiguous to save the statute about whether California patients could come and register. The Attorney General's office agreed, and the program permits out-of-state residents. Folks, I know somebody was talking about rescuing Wisconsin patients to Michigan. There are Wisconsin patients who are registered in Oregon, so that when they travel to Oregon, they're good with the medicine.
Mm-hmm.
So the point is that even when it looks impossible,
absolutely,
and even when you lose in court, you can still have a positive effect on changing the law.
I've always said if we don't piss into the wind, who will?
I've been working with my local medical marijuana community such that every time someone gets pulled over by this rogue cop in my county, that they can expect a FOIA request to come within a week or so. So he knows that every time he pulls someone over in this county, he's going to get a FOIA request from my office about the stop. So that's the way I've been responding.
It's paper training the cops. And I'll tell you, it's a fun thing. I do a ton of 1983 stuff. And the fun part of it is you get these cops who are the neighborhood bullies, and you bring them over to federal court. And they're looking around and they're saying, this isn't my courthouse anymore. This isn't my judge anymore. And, they get, it's an eye-opener for them to get their butts dragged into federal court and have to sit in my office and get deposed by me and answer questions that they don't want to answer. And I think there is a lot of paper training that goes into that. But they, after enough, they can actually, you can stop things that way. Mm-hmm.
My question, looking at it slightly differently, let's just suppose that we're going to be filing your civil rights action or lawsuit in federal court. The federal court system is going to look at it and say, the federal government does not recognize California's law. We've chosen not to invade California and stop the evildoers of Colorado collectively, but you said having a Colorado license plate is not
A
reasonable
protected
suspicion.
place, right.
Are we sure they're not going to make having a Colorado license
Well,
plate
you
reasonable
know,
suspicion?
another thing I say frequently is that unfortunately the Constitution is only as strong as the people charged with protecting it. And when the people charged with protecting it are wearing black robes, they've got large brains but very little backbone supporting it. The Constitution is simply not all that strong, and that is unfortunate. And there's no remedy for weak judges. And I again go back to these Guantanamo Bay cases. I could go on for another day and a half about the lack of spine in the D.C. Circuit Court of Appeals. But,
so there is potentially a risk that the federal court
well,
can say,
I don't think they'd go that far. I don't think they will just simply say no. They won't affirmatively walk out and grab you and say, and furthermore, you know, we're going to make, that is reasonable cause. If you're from Colorado, I don't see that as a realistic possibility.
David,
Uh-huh.
I think once Colorado gets the retail cannabis business going with the law they passed last week, and don't forget to talk about your new lawsuit, I don't think a Colorado plate is going to be the profile. It'll be the Kansas people that are seen coming across the border.
Right.
Which is very interesting.
That's
Yes.
what I was going to say.
They'll be-
Anybody leaving Colorado is going to, you know, these pot tourists going back to Kansas with a load, you know. It's really anybody. So it'll be very interesting to see how that works. But that's an excellent point.
That's certainly what happened in Idaho, coming out of Oregon.
Right. That's going on in Ontario, Idaho right now.
I'm sure. But you've pinpointed it to Ontario, Idaho.
Damn straight.
And so if somebody actually wants to see, you know, and really launch a good investigation and get the goods on these cops for lying. I mean, the Fourth Amendment still, and that is the talismanic amendment. When I was arguing in the Supreme Court, I said, what you're doing is you're creating a super amendment that trumps every other amendment. The Fourth Amendment is the super amendment. They can violate, you know, equal protection. They can violate the First Amendment, free speech. They can violate anything they want to violate as long as the Fourth Amendment is not offended. Anything goes. You know, had Martin Luther King dropped a gum wrapper on the ground before his I Have a Dream speech, they could have arrested him for littering and taken him away.
Taser.
You know? And that's what they're doing by elevating this Fourth Amendment to talismanic levels, and it's very scary. And this is why we have to constantly try to beat that back.
It's not marijuana related, but has anyone looked into the South to see, okay, now that racist officers can pull over black people, that we're seeing a resurgence of profiling, and then the NAACP might get involved.
Mm-hmm. Yeah, I don't know what the answer to that is. Mark?
David, in reference to what you were saying about getting a freedom of information request, or maybe it was a Quora request under the Colorado Open Records Law, to get the officers' personal records as far as the tickets that he was issuing. Didn't you run up against a motion to quash or whatever your subpoena, and how did you address that? Because when I've done that, it's like the judges, again, the guys in the black robe say,
well, I mean, this is what was unique about the Louis Lemon case. In the other case, the civil rights opinion that came after that was Whitfield versus Eagle County. If anybody's interested in that, I think it's in the materials. They filed a motion to quash my subpoena, deuces take 'em, saying this is burdensome, this is oppressive, and they did all their usual whining and crying. And, we had to show that we believed, based on a preliminary investigation, that this is what was going on. And Judge Kerrigan initially said, all right, look, I'm going to order that you give up your records for the last month. And that's not that burdensome. I'm not going to grant the SDT for the last year. But I will grant it for a month. Give it the records, see what you get, and then come back if you need more. So we saw, immediately, virtually every stop was from an out-of-state plate, mostly California, with a Spanish surname. Showed that to Kerrigan, he said, give him everything at that point.
Were you required to provide affidavits from some of these people that you're investigator? I mean, just so that Kerrigan would go along with the
No, because we didn't know who those people were. The only people I knew were my client and his co-defendant. And, but I said, Judge, we can't know what we don't know. But I think this is what's happening here. And I had provided him, there was enough stuff, public record on Operation Pipeline, and then raising the question of why is the sheriff's department enforcing traffic on an interstate highway? That's not what they do. That's not their job. That raised enough of a red flag in Kerrigan's mind that he granted the SDT on a limited basis. We then brought in the goods, and he granted it broadly. And then we flew in people who were outraged by the whole thing, to come in and testify. It's actually pretty funny. At the hearing, we brought in this surfer dude from California, a white kid from California, and so I'm questioning him in front of Judge Kerrigan, who is sort of an old, crusty federal judge. And so he's on the stand, and I said, so what happened then? And he says, so this cop says, I want to search your car. And I asked this kid, I said, so then what was your response? And he says, my response was, dude. and Judge Kerrigan leans forward and says, what was your response? Dude. Kerrigan says, I'm sorry, what was your response? I said, I think what he's saying, Your Honor, is, you've got to be kidding me, sir. That's what that means, Your Honor. He said, oh, okay. But there will be a great deal of litigation as, different states have different laws, and this is why DOMA and the litigation on DOMA and California on gay marriage is important to this issue. Because if the states have to acknowledge full faith and credit for every other state, it's going to have an impact here. So those are going to be some very big decisions coming up in the very near future. There is other litigation. Mark just mentioned, I filed a federal civil rights lawsuit 2 days ago after Hickenlooper signed into law the enabling legislation for Amendment 64. Because some bright light in the state legislature decided that, fine, magazines like High Times, who is now my client, the Daily Doobie, and the Hemp Connoisseur, all have to be sold either only in retail marijuana establishments or, if sold in other outlets, behind the counter, like porn. And so we filed a civil rights lawsuit that is now pending in front of Judge Mage, who many of you may know, who does not take kindly to constitutional violations and yells at constitutional rights violators and enforces the Constitution. So High Times, the Daily Doobie, and the Hemp Connoisseur are in court right now. The ACLU is getting ready to file a companion suit on behalf of the Tattered Cover Bookstore and various other distributors of magazines in the Colorado area. So we're covering all the bases. We've got the magazine, publishers, and we've got the booksellers all going to be joined up in a federal lawsuit very shortly. The magazines have already filed, so it's in court right now.
Is that a separate law, or was it?
It's part of the 57-page bill that Hickenlooper signed, going from A to Z, enabling marijuana. Mm-hmm.
I had a question. It's really a technical question about car stops. Maybe somebody has an answer. I've been told that now police have technology that they can capture a license plate, like as you're driving north to Humboldt County in California. Then as you're driving back, it'll recognize it again, tell them how long you stayed for, basically, and then they'll use it. Well, somebody's driving north, they stay a couple of days, they're driving south. Does anybody know if that's true?
Well, I know there is technology. I assume that is true because I know there's technology in police cars now where the cops will pick out these little seedy motels. Every town has them, and it's where people with a lot of warrants end up staying. you know, when they're living out of their car half the time, and then they've got this motel. So they'll just drive through a parking lot, and their scanner immediately reads every license plate in the parking lot as they drive past and pops up, oh, a warrant is associated with this guy's plate. And then they'll go make a bust. So yeah, that technology exists, and I'm not at all surprised that they've developed it further. Not just do you have a warrant, but when were you last scanned, where were you headed, where are you coming from now, how long ago was it?
There's 2 more hands up. Why don't we, 3 more?
Quick question. Going
Three
back
more.
to the First Amendment issue,
You go last, Jerry.
magazine issue, how do you, split the baby in terms of having the federal court deal with the conflict of law issue? Is there some sort of recognition?
There's no conflict of law on the First Amendment. You know, they cannot have content-based restrictions on free speech. You could make a book called How to Make a Bomb, you know, and sell it. And they can't restrict it. The only restrictions on free speech can be reasonable time, place, and manner restrictions, meaning you can't have a brass band or a megaphone in front of a hospital at 3 o'clock in the morning, regardless of what your message is.
Is there a danger, though, that the court will actually opine as to, the validity of the Colorado law versus?
No, this is purely a free speech issue. It has nothing to do with, do you like marijuana, do you hate marijuana, is it good, bad, or constitutional, not constitutional? So no, there's no spillover on that front.
The challenge is the specific section.
It is, yeah, the whole statute isn't being attacked, just that one little paragraph saying you got to treat pot magazines like porn, and that's it. Mm-hmm.
So to answer his question, the technology is absolutely in existence. It's Denver parking meters. I mean, they go around, they scan every single car in. They know how long you've been there. Have you redeposited your money over 2 hours in the meter? And have you moved 100 feet in accordance with the ordinance rules? It's a cash cow for Denver.
So there's no more going out spitting on your tire and erasing the chalk.
Yep. So there's no doubt that the technology is used. What are they using it for? I'm sure everything they can come up with.
Okay, one more, did you say, Mark?
Brother Goldstein has a question.
I wanted to thank you, David, for what you're doing for all of us. It's very
Well, Terry, thank you so much. I appreciate all of what you're all doing for the world here, so thank you.
And I would say that there are restrictions. For example, you can't put a bottle of Jesus if you're in an after-school affair. And with respect to the cameras, every toll road now, I don't know if you've noticed, I get bills regularly that have my mug and the license plate, as I'm avoiding a toll booth. So they know exactly where you are, and it's not an accident that they were able to find these kids from Lord and Taylor's.
Oh, absolutely.
London has one of those on every corner, and no longer do they have to erase them every 30 days. It's stored up in some cloud someplace forever, and they can determine that. And we're going to talk about that tomorrow. But there really is a danger that our privacy is a fleeting concept, even if we do talk about the Fourth Amendment. I think the Supreme Court is starting little by little direction.
I hope you're right. As my grandmother used to say, from your lips to God's ear. So anyway, thank you all very much.
David Lane, we're going to take about a 15-minute break, not 20, closer to 10, but I'll say 15. We have Jerry Marin coming up next. Please stretch your leg, but please be back in 15.